In this episode, fan favorite James Koukios, editor of the Morrison Foerster International Anti-Corruption Newsletter, joins us to discuss the developments reported in the January and February newsletter. I know you'll enjoy this episode.
This is Bart Peterson, and you are listening to the FCPA Compliance Report on the Compliance Podcast Network.
The FCPA Compliance Report is a production of the Compliance Podcast Network. Hello, everyone. This is Tom Fox back again with fan favorite James Koukios, partner at Morrison Foerster and head editor of the great monthly Morrison Foerster International Anti-Corruption Newsletter. James, first of all, welcome back.
Thanks, Tom. I know this is the January newsletter, but we're recording this a little later, and our Wolverines did pretty well in the NCAA. They didn't make it all the way, but they did a pretty good showing there.
They did. So it was nice to see us finally back where we belong.
Go Blue.
Go Blue. So from your January newsletter, you noted that the Transparency International Corruption Perception Index, or the TICPI, was released. And I think that's one of the most ubiquitous documents that is known in the compliance profession. But James, what I really wanted to maybe use that is to explore using the TICPI as a tool. Many compliance practitioners will use it not simply as the Bible, but really as the only source. And it is a perception of corruption. So it's a survey. It is somewhat general. I think there are other surveys that are more detailed. But I was wondering, now that you are kind of on the other side, how do you see using the TICPI? Is it a tool? Is it the tool? Or is it a suite of tools that you might use?
Yeah, Tom, I think I would describe it as one of the tools in a suite of tools that you should use. I think it's a definite benchmark that everybody should use. The government itself uses it. You know, when we were at DOJ, for example, we looked at it. We asked companies if they had looked at it, and if they had not looked at it, and they later had an issue in a country that was ranked poorly on the CPI, we would kind of look sideways at them. So I definitely think it's one of the most important tools that a compliance professional should use. As you mentioned, it's a perception index, and it's not infallible by any means. I mean, there are certain countries that may rank very well one year, but you learn later on that there was a bunch of things that wasn't public that could cause them to fall later. And just because they're clean in one area doesn't mean they're clean in the area where you're doing business. So it's not the only thing a compliance professional should look at, but it's definitely one of the things that should be in the toolbox.
So many compliance practitioners, I think, will use it as a basis to make a determination of the appropriate level of due diligence. So if it's a low-risk country, perhaps level 1 to level 2, medium to high risk, level 2 to level 3. Do you find that an appropriate use of the TICPI?
I do as a rough cut. Obviously, compliance resources are limited, and you have to make some determinations. But that doesn't mean that an individual deal should not get more enhanced due diligence as well. So to start with, to say that use the CPI as a rough cut to say deals that take place in these countries should get more enhanced due diligence, that doesn't mean it's the only factor that should be considered. There should be others as well. The nature of the deal, third parties, which government agency you're dealing with. But I think, as one factor in determining what your enhanced due diligence program is going to look like, I do think it's a valuable and important factor. What about you, Tom? You think?
I think it's certainly one tool. Actually, I would agree with that. It's great for a rough cut. But if you've got additional red flags that have popped up at this point, or through other information you've determined they may be certified by an agency that we're both familiar with, you have some level of comfort that they have a compliance program. Perhaps others in your industry have used them as an agent, and you can actually get kind of a informal reference. But as a rough cut, certainly I think so. Let me ask you to maybe go back in time and put your DOJ cap on. When does a prosecutor, would they test the risk management program, sort of what I would call the 5 steps of a business justification, due diligence assessment, and then performing the due diligence, then assessing the due diligence and clearing any red flags and putting terms and conditions in a contract. Is that something a prosecutor would want to see?
Absolutely. 100%. I mean, whenever there would be a problem with a third party, which of course is the biggest risk area for anti-corruption, we would ask them, what was your third party due diligence program like? How did you assess this third party? What did you do in terms of due diligence? How did you assess that due diligence? And, what kind of contractual terms and monitoring did you do during the engagement of this third party? So absolutely, for sure. And that would come out, whether they used the CPI, for example, would come out during that as part of the analysis. Was that part of your due diligence assessment? But those are exactly the types of things that we would ask for. It could be a little complicated because sometimes that work is done by lawyers. And so sometimes companies would say, we want to share that information with you, but we can't because it's privileged. And that put us in a little bit of a rough position because we had a company on the one hand saying, trust us, we did a good job, but we don't want you to see any of the work that we did. And it would be kind of hard to credit that without being able to see the work we did. But we also didn't want to ask anybody to waive privilege if they didn't feel comfortable doing that. So, but generally speaking, that's exactly the type of analysis we would want to see in a program. And certainly during compliance presentations, when companies would describe to us their third-party due diligence, we would want to hear those exact things that you named, Tom, how they went about doing what their third-party due diligence program looked like, at least structure. And just to expand on that, one thing I found very effective when I was in the government also was statistics. How many third parties were run through the due diligence program, how many red flags were raised, how many third parties were rejected because of the due diligence that was raised, and then what was done in order to block those third parties in the system. When companies would provide that kind of detail to me, when I was on the enforcement side, I found that extremely moving and effective because it showed that there was, it wasn't just a paper program, that there was really something behind that.
I'd now like to turn to a case that the U.S. Supreme Court denied cert on, and I'm probably going to butcher the name, but it's Samir Khoury, I think.
I think that's
okay.
Right.
Well, he had an indictment unsealed a few years ago, and it turned out that indictment originally came down in 2006. Was unsealed in 2016, and he was trying to get the indictment thrown out, saying that he didn't have his right to a speedy trial. I don't know what your thoughts on that might or might not be, but I was intrigued that an indictment would be sealed for that long. I was wondering if you could shed some of the light on why that could happen.
Sure. Yep. Yeah, exactly right, Tom. The date's a little bit different. He was actually charged under seal in 2008, if I recall correctly, but it was unsealed 10 years later in 2018. And the charge is related to alleged kickbacks from even older than that, from 1996 to 2003, to secure oil contracts in Egypt, Oman, and Qatar, among other countries. Usually the reason when I was at DOJ, usually the reason that we would seal charges would be because oftentimes it would be that the defendant himself was not in the country. And we wanted that person to continue to travel freely with the hopes that we would be able to catch him if he traveled to a friendly country, or better yet, even the United States. I remember we did have some defendants along the way that we charged under seal who ended up flying to the United States. And we were very happy that we had charged them under seal because here they were in the United States. Otherwise, they may travel through a friendly law enforcement country, like, for example, Panama or somewhere else where I remember some of my other defendants who were charged under seal were also picked up. And so oftentimes it would be a law enforcement reason to file those under seal, so that they wouldn't be scared off from traveling and that we could eventually catch them. I don't know exactly about Mr. Khoury, what his situation was. He was a dual U.S. and Lebanese citizen. I'm not sure if he was in Lebanon at the time or somewhere outside the United States. And I don't recall, I wasn't there when the decision was made to file him under seal. So I don't know the specifics of his situation, but that would be the general situation. Now, it turns out if the person never travels or it never comes to fruition, then those charges may never be unsealed, and it could take a long, long time. For some, I don't know the exact details here, but somehow Mr. Khoury found out that he had been charged under seal, or at least or perhaps DOJ unsealed those charges because they were getting so old, and he moved in the district court, then appealed to the Fifth Circuit, and then tried to go to the U.S. Supreme Court to say, these charges are really too old. The witnesses have died, or their memories have faded, or I can't, for whatever reason, can't get them to defend myself if I were arrested on these charges. So you should dismiss these as a matter of due process. Thus far, that argument has been unsuccessful, but it's an interesting argument, and something that could certainly happen in these situations where a charging document has been under seal for so long.
Next, I'd like to turn to a guilty plea of Daniel Camaretto that came out of the Sergeant Marine case. What can you tell us about that?
Sure. So Camaretto was a former manager and trader for Venezuela's national oil company, which we've talked about probably many times on this podcast, PDVSA. And back in September of 2020, DOJ announced that it had reached a resolution with Sergeant Marine. And at that time, it also announced that it had reached a number of resolutions with individuals, and that it had charged Mr. Camaretto under seal and was unsealing those charges as well. And I think if you go back to a long time ago, when the criticism used to be that DOJ would only charge companies and would never charge individuals, that September 2020 announcement really was one of those examples where DOJ was trying to say that's not true. We charge both companies and individuals. And in fact, we're going to announce a whole bunch of individuals at the same time that we announced the corporate resolution. Now, it turned out several of the individuals that they announced back in September had been cooperating with the government and had pled guilty under seal, and that they had also charged Mr. Camaretto under seal. Likely what that meant was because they were going public, Camaretto was going to know that he was probably in the crosshairs, and so they went ahead and unsealed the charges against him as well. And then it took a couple months, and he finally did plead guilty in January of 2021. It's also interesting, I think to point out, I think we've talked about this before, Tom. Camaretto himself is alleged to be an official of the foreign government, and so it's interesting also. DOJ continues to bring charges not only against bribe payers, but alleged bribe receivers as well, using the money laundering statutes.
And once again, as I recall, Camaretto had actually moved to the United States, and he's one of a number of ex-PDVSA employees. And all I can conclude, if it's so bad you're going to fly to the country that can get jurisdiction over you to live, it must be very bad in Venezuela.
That's true. That's true. He was lawful permanent resident of the United States, as well as a dual citizen of Venezuela and Italy. Maybe he should have gone to Italy, Tom, to your point.
I'd like to now turn, James, to the February newsletter. And we had a couple of different stories regarding the serious fraud officer, the SFO. One perhaps not so good, and one perhaps a little bit better. And the KBR decision regarding document production, and then the Paul Bond was convicted on retrial. I was wondering what you saw in the were you surprised by the KBR decision, or did you find it really followed at least your understanding of English law?
I have very little understanding of English law, Tom. I defer to my UK partners for the nuances there. But it was still a very interesting development that even this American can find significant. If I could summarize it briefly, in February of 2021, the UK Supreme Court essentially limited the ability of the UK Serious Fraud Office to compel production of foreign evidence. In that case, the SFO was trying to get documents from KBR in the United States. And the SFO read a particular statute under English law as allowing for that. It's not unlike, in my mind, if you look at Bank of Nova Scotia subpoenas in the United States, where DOJ takes the position, and courts have agreed that DOJ can get documents from foreign banks if they have an outpost in the United States. So it sounded a little bit like a Bank of Nova Scotia subpoena of some sort. KBR had UK offices, but they were actually the SFO was actually seeking evidence from the U.S. entity outside of the UK. And basically the Supreme Court of UK said, no, you can't do that. The statute doesn't go that far, and you can't compel a non-UK company to produce documents from outside the UK. It's obviously a setback to the SFO. It's going to make foreign evidence gathering much more cumbersome. And of course, in foreign bribery cases, it's going to make those investigations more difficult. However, it does not mean that the SFO is without any kind of redress. Our estimation is that the SFO will likely continue to compel UK companies to produce documents that are held overseas, and that when the documents are from a non-UK company overseas, that the SFO will use the Mutual Legal Assistance Treaty process, which is what the DOJ prosecutors are supposed to do also, despite the presence of Bank of Nova Scotia subpoenas anyway. So, this is clearly going to make it more difficult for the SFO to do foreign investigations, but not impossible. It'll just take some more time to do that. Regarding the Paul Bond trial, this is an interesting one. Mr. Bond this is actually his second trial. This relates to the Unaoil investigation. He and two co-defendants were actually tried back in 2020, and a jury convicted the two co-defendants of related crimes, but they couldn't reach a verdict as Mr. Bond. So the SFO went back at it. They tried Mr. Bond again, and this time they got a conviction related to Mr. Bond's alleged involvement in a scheme to bribe officials at the Iraqi South Oil Company in order to secure lucrative oil contracts in the late 2000s. The SFO sometimes gets some hard knocks for some trial losses they've had in foreign bribery and other cases. But I kind of see it differently. I mean, first of all, they're not afraid to try cases. They often do try foreign bribery cases. And, just because they lose a couple doesn't mean they're not good at it. And I think the Bond case shows that, if at first they don't succeed, they can try again and win again. And that's now, in this one case, 3 jury verdicts of guilty. So I think the SFO gets kind of a bad rap for not being very good at trials. I think they're actually pretty successful in what they do. And this is another example.
A long time ago, a senior partner I worked for said, if you never go to trial, you never have a loss.
That's right.
So I learned pretty early on that get your tail down to the courthouse when you can't get it resolved. So,
we had the same reputation at DOJ for a while. In the FCPA unit, we had a couple bad rulings in the alternate breach case, but then, I went down and tried Eskenazi and we won that. And, they've been on a pretty good streak ever since. So just because you lose some cases doesn't mean that you're not, you can't bring them and you can't win them. In fact, I think the SFO and DOJ have pretty good records despite a few losses.
I would agree. We had a Samsung Industries resolution of a corruption matter with the Brazilian authorities, and it was through a leniency agreement. And I was wondering if you could maybe tell us or talk to us a little bit about what a leniency agreement is in Brazil. Is it equivalent to a DPA or an NPA, or is it really a Brazilian flavored document?
It's a little bit of both. So they don't have corporate criminal liability in Brazil, and so they don't do deferred prosecution agreements. But a leniency agreement is probably, I'm sure there's many nuances that my Brazilian colleagues will say this is oversimplified. But it is very similar to a deferred prosecution agreement or a settlement agreement here in the United States with a U.S. enforcement authority. Essentially, the company agrees to resolve an investigation with Brazilian authorities. And as a result of that, there is some kind of benefit given to the company, whether it be a reduced penalty or some other kind of benefit in that regard. And that was one of the things that Brazil has recently introduced. And they've used them in a number of Operation Car Wash related cases, including this one.
We also had an extradition from Spain to Mexico, I think of a former Pemex official, and a little bit unusual, I think, to see Mexico asked. for anyone to be extradited, perhaps even Spain. I was wondering, is there really was there significance to this action in your mind?
There's two aspects that are significant in my mind. Number one is this investigation itself has the potential of being very, very large in Mexico. We've covered this before, I think, Tom, in a couple prior podcasts, and we regularly report on this in our top 10. But currently there's a major investigation going on in Mexico regarding alleged corruption at Mexico's national oil company, Pemex. There was a while ago, their former president of Pemex was arrested in Spain, extradited, and he has alleged that several former Mexican presidents were involved in the corruption at Pemex as well. So that's obviously big news. This fellow who was just extradited from Spain in February of 2021 back to Mexico is alleged to have been one of the people who paid a bribe to the former president of Pemex in connection with the sale of a company to Pemex back in 2012 when he was president. 2014. It was a fertilizer plant that Pemex had bought from the former CEO of Pemex was overseeing that. So I think it's significant, number one, because it's a big investigation in Mexico. This shows that it continues to have legs, and this fellow could cooperate against others in the government of Mexico and whatnot. The second reason I think it's significant is it continues to show international cooperation in foreign bribery cases. We've had a number of alleged bribe payers and bribe takers from Spanish-speaking countries arrested in Spain and extradited to their home countries for prosecution. So not only is this a big deal for Mexico domestically, but it shows the international cooperation in foreign bribery matters.
James, I wanted to end with at least the winding down of Operation Car Wash and the prosecutions, although as we've seen with Samsung, there may be a longer tail on this, and really wanted to take the opportunity to ask you if you could assess its overall impact in the fight against bribery and corruption. Obviously, we had significant enforcement actions, but to my mind, we saw a level of cooperation possibly not seen before, but certainly a very high level between U.S. and Brazilian prosecutors. We saw the real first international sharing of fines and penalties. We saw a truly international scope of investigations and companies involved all the way to Singapore and to Brazil and back. And just really get your thoughts on what does car wash mean for the international fight against bribery and corruption?
Well, I agree with everything you said, Tom. I actually don't know how much more there's left to say because what you said was spot on. I mean, this was probably, and I don't think this is going out on a limb, the biggest foreign bribery case of all time. As you mentioned, there were enforcement authorities from all over the world involved. They cooperated in every aspect, from building cases to sharing defendants to sharing the proceeds of resolution actions. And I think it really brought Brazil in particular into the fold of major anti-corruption enforcement countries that really cooperate on an international scale. I still remember I was at the FCPA conference at the National Harbor in Washington, D.C. when the first Lava Jato or car wash charges were handed down. I was actually at lunch with a bunch of Brazilian lawyers, and all of them got very quiet and were looking at their phones. And I asked them, what was happening. And they said that there had just been major enforcement actions announced against very significant industrialists in Brazil and major companies that they thought up to then was impossible. I mean, they really saw this as the end of impunity in Brazil. And it really stuck with me because I could see the reaction physically for these Brazilian lawyers to what they were seeing happening in Brazil. And so for Brazil itself, it was a major movement. And then for all the reasons you discussed, Tom, that cascaded throughout the world and really became a huge moment for anti-corruption as well. Unfortunately, it's ending on something of a sour note. It kind of ran out of steam at the end, kind of ran out of political support, and some of the convictions are starting to be reversed a little bit. And so one question going forward is how much of a lasting impact this will have in Brazil. I think it will continue to have some. You can't reverse all of it. And maybe most importantly, the citizens of Brazil were behind it. And so there's going to be an appetite for this in the future. But we'll have to wait and see, how long lasting and how deep the impact is. But over the last 7 years, there hasn't been another anti-corruption investigation that's had anywhere near the type of impact that car wash has had. So I'd say it was massive impact and a monumental case.
Well, I think that's a great note to end on, James. I know the March newsletter's out, but we're going to save that for another episode, perhaps pair it with its sister April. And looks like you're having a beautiful spring in Washington. So hopefully things will be getting back to normal-ish.
Let's hope so.
Okay, thanks a lot, and I look forward to continuing the conversation.
Thanks for having me, Tom.
Hello, everyone. This is Tom Fox again. I'd like to thank you for listening to this episode of the FCPA Compliance Report, a production of the Compliance Podcast Network. We have a great new show on the Compliance Podcast Network called MoFo, which is a podcast of the law firm of Morrison Foerster, hosted by James Koukios. Check that out on the Compliance Podcast Network. Also, we have a new podcast, Survive and Thrive, where with my co-host, Courtney Nordrum, we take a look at compliance disasters, some of the lessons learned and red flags missed, plus what you can do to avoid them going forward. I know you'll enjoy this great new series, Survive and Thrive, which posts every other Tuesday on the Compliance Podcast Network. Thanks so much for listening, and I look forward to visiting with you again next week.